Mr. Chief Justice, and may it please the court. My name is Mike Salazar, and I'm here alongside my co-counsel, Ms. Victoria Lovato. We represent J.L. Garlis, the appellates in this case. At this time, I would like to reserve 2 minutes for rebuttal. There are 3 questions before the court today, all of which we think are resolved in favor of the appellates. The first is strict scrutiny is the appropriate level applied here because it involves a racial classification as it relates to a reparation program paid to the descendants of enslaved Africans. Secondly, we would argue to the court it is unconstitutional to establish a reparation program paying precisely $20,000 in direct parity to the Japanese who were interned during World War II, as $20,000 would not satisfy just compensation under the takings clause of the Fifth Amendment. And finally, we will submit to this honorable court a DNA distinguisher differentiating those who have 40% DNA from those who have 39% DNA or below creates an unjust system whereby people who would otherwise be justifiably entitled to reparation benefits are excluded arbitrarily. As such, it does not pass constitutional muster under the 5th and 14th Amendment. I will be addressing issues 1 and 2, and my co-counsel will be addressing issue 3. Now, when determining the level of scrutiny applicable to the case before the court today, I urge the court's focus to remain on the facts surrounding the case and the framework established by the court in TAMUCC v. United States. In delivering the opinion of the court, Justice Hugo Black noted any legal restriction which curtails the civil rights of a single racial group is inherently suspect and should therefore be subject to the most rigid scrutiny.
So what law has been passed that, because to my knowledge, there hasn't been a law passed yet. The court only has power to review and remain laws that passed. So what's that?
Thank you for your question. It's not per se so much a law that has been passed, Justice. It is the fact that my client's Fifth Amendment right has been violated as not getting through the, and as well as an equal protection right, as not through the Fifth Amendment or the Constitution, as not being adequately compensated for a lifetime of servitude and pain that was inflicted and endured, that was promulgated, perpetuated, and permitted at the hands of the federal government.
So in brief, counsel, you're arguing that it is a state action or a lack thereof a state action that requires remedy here.
Yes and no, Your Honor. What we're arguing today is that there was a state action that initially instituted slavery. However, the federal government does not have clean hands in this fight. The federal government has grossly benefited from the institution of slavery and has also passed several laws and pieces of legislation showing that they not only permitted, they promulgated and perpetuated the institution of slavery. Some of those, in fact, the federal government has a history of recognizing the human body as property subject to ownership in the following instances. The congressionally approved legislation titled Fugitive Slave Law of 1793, the congressional reenactment of the Fugitive Slave Law of 1850, the District of Columbia Compensated Emancipation Act, which was signed into law by President Abraham Lincoln, offering a $300 reparation to any enslaver for the reluctant release of an enslaved African within the District of Columbia. In the case of Dred Scott v. Sanford, in this case, the court held that a Black man had no standing to file suit in federal court and was deemed to be the property of his enslaver for life. The mental impact that slavery has bestowed upon society, however, did not end when slavery did. The terrorizing turmoil preceding the abolishment of slavery left a lasting toll, tarnishing our society through 90 years of Jim Crow laws promulgated and perpetuated at the commitments of the federal government in Plessy v. Ferguson, and being the sole reason for 60 years of separate but equal and 35 years of race and housing policies. As we well know, the Fifth Amendment explicitly states, no person shall be deprived of the right of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. We interpret private property to extend to anything owned by anyone outside of the federal government. In fact, private property has historically been interpreted as extending to include a person's right to private property of one's own self, one's own actions, and to relish in the yielding of one's own labor.
So that argument you're making there with respect to private property in the postbellum period, is it not true that many slave owners were compensated. So almost this argument of compensation could cut both ways. It could be compensation for those who have had slaves taken from them. Is that not correct?
There was a piece of legislation, Mr. Justice, which I did mention, which was the District of Columbia Compensated Emancipation Act, which was signed by Abraham Lincoln. That did provide reparations to enslavers within the District of Columbia. They were offered a $300 reparation for the release of any slave. However, we would argue to the court that no man possesses the right to have ownership over another human being. And in that, there has been a gross misjustice allowed within the United States of America at the commitments of the federal government. And in this case, the government has grossly deprived innumerable African-American citizens their right to just compensation, and a $20,000 reparation would be an egregious miscarriage of justice in exchange for a lifetime of servitude under the Fifth Amendment. For the foregoing reasons, we humbly plead with the court to reverse the decision of the Fifth Circuit, reaffirm the decision of the Ninth Circuit, and find the federal government in violation of the Takings Clause of the Fifth Amendment.